Hello, everybody. Hello, C-Rex. Hello, Nana Laura. Hello, she's a maker. She's a smile maker. Hello, Ixamo1. Hello, Joey Bag of Donuts. And oh, that's terrible. I am so sorry. Kia Ora. I can't say the last part. I'm so sorry. Happy Halloween, Yvonne McLaren. I still haven't gotten that. I know you told me the pronunciation, but I'll still screw it up. Please help me. Hello, Shane. Shanny! Good to see you, buddy. Hello, Tiana Miller. Hello, my sweet Spider-Man. Hello, Eileen and Carlin. Welcome. Hello, Sir Philip. Hello, Auntie M. Far now. My brain can't process that with how it's spelled. I will try. Far now. Kia ora, far now. Thank you. This is Ava. Ava, since it's Halloween in New Zealand. Oh. Far no. Is that right? Far no. There. Now Ava and I have our Halloween costumes on. I will try really, really hard to get it right. She is. Oh my gosh. The things she tolerates for Blue Buffalo treats, right? Oh, Bobby C, thank you. You'll be fine. Oh, you guys, I am such a professional. The case is done. It's exported. It's just on that computer. So it'll be just 2 seconds while I move it to this computer. What it is I had exported it directly to my external drive one day. Well, that's not in the computer every day. Oh, no, stop, no. I'm so good at this, aren't I? So yeah, I exported it directly to my external drive, and then when that was no longer in there, it defaults to some weird, C users, my name, CapCut, blah 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 blah, like 20 folders deep, and yeah. Now, in the only way that I can find it I have to just remember the next time I export it to put it in a specific spot that that I know exactly where it is, because the external's not in there for it to go there. And oh. You're far too kind. It is not in use. It is not in use. I'm done using it. I exported it already, and I'm trying to eject it. Come on. Oh, Ava, did you have to? Okay, got it. Oh, you guys are so sweet to me. So, I've been peeping on this judge for a little bit, Judge Odette, and I like him. He's just I don't know. He's an old man. You know, I love old men. He's not too cranky, but he's just direct. He's, get to the point. I think he even says that once. So of course I'm gonna love him. Yeah, right. Oof. She's cutting some cheese over here. Oh, she's gone now. I'm scared. I might have to do another instantaneous PAWFURM potty break for her, because yeah. I think she's probably waiting by the door for me. She's like, lady, you know what I did, so you know where I'm going. Yeah, right? Speaking of which, we might have to go stay with Grandpa again this weekend. She loves staying with Grandpa because he is a man of the cheese tax. He abides by the cheese tax very well. And the peanut butter sandwich tax, and the chicken tax, and the ham sandwich tax. Basically anything my dad eats, he shares with the dogs. He knows how it's done. I'm getting there, Ava speaks.
Burke Law versus Linda Newton. I'm showing no service. Linda Newton here.
Your Honor, we were unable to serve Ms. Newton. We are asking for an adjournment on this matter to attend service again.
Miss Newton?
Yes. Oh,
No. I don't show proof of service either here. Here, you gotta serve, right?
Yeah.
Are you disputing the point?
yes.
Okay, raise your right hands. Promise to tell the truth, whole truth, nothing but the truth, so help you guys.
Yes.
All right, you can remain in small claims court, or you can have it transferred to general division of the court. If you remain in small claims court, you can give up the right to be represented by a lawyer, have a jury trial, appeal the decision of the court, and seek more than $7,000. Do you wish to remain in small claims court?
Yes.
Sergeant, do you wish to remain in small claims court?
Yes, Your Honor.
Sergeant, why do you believe Mr. Newton owes you $1,758.96?
Your Honor, this is for services rendered on a divorce case for Ms. Newton. This case, we did take this case all the way through and get it resolved and finalized. Our agreement was a $3,000 retainer with $250 a month. Ms. Newton did make a payment. However, she did not pay the remaining balance. She was given credit on the invoice for the amount that she did pay. an amount in $1,940, which left a balance of $1,758.96.
Ms. Newton,
Yes.
your response?
I have the breakdown for what I'm being charged for and I was never informed that I was gonna be charged for text or phone calls. I assumed she told me to contact her anytime freely. So I have the text messages here and
Is there a fee agreement?
Your Honor, our standard retainer agreement is the same. I don't see it in the file, so I do apologize for that. However, our standard agreement is $250 an hour with minimal fees. Any out of court appearance of 2 hours and a 0.2 for minimal contact. Ms. Newton was not charged for every contact that she made to us. I never charge for every contact that is made. However, if there is an extensive conversation or we're texting throughout the day, I generally do charge for one communication.
Let me ask you this, Ms. Newton. Why would you think she wouldn't charge you for a phone call or text message?
Because-
You're basically, when you hire a lawyer, you're hiring them for their time.
right,
So their time, whether they're talking to you in person, or talking to you on the phone, or talking to you by text, it all takes time. And I don't know, if I charge somebody $500 an hour, okay?
mhm,
Then you break that down, it gets broken down some way,
right,
And if you call them, they can break it down into quarter hours, 1/6, 1/10. There's different ways to do it, but the thought that it wouldn't be charged at all is, I don't think that's very reasonable.
I get that, but our verbal contract, I told her I was disabled, that I couldn't afford much, and that basically I needed help with the paperwork. So I gave her a $2,000 retainer fee. She said, we'll go from there. And like I said, I was never informed that I was gonna be charged for text messages. She gave me her cell phone number, said, contact me whenever you feel. And basically, when I would contact her, I would ask her if there was any updates. Because she was waiting for my ex-husband to reply.
Okay, so how far did the case go? Did it go to trial or
No,
did it get resolved?
yes, he agreed to everything. Basically, I just needed help with the paperwork.
Okay. Do you owe the money?
I mean, from what she sent me, it says I owe, but I don't agree with everything that was on the
What
paper.
don't you agree with? How much do you think you owe?
Like I told her, I was disabled. Well, I am disabled and I get a monthly check. So there wasn't much that I could afford. And she reassured me and she was like, just give the $2,000 down and then we'll go from there. And there was even conversation of having my ex-husband pay whatever was remaining because of me being disabled, and he makes at least 3 times more than what I get a month.
Was it a settlement or did the court make a ruling?
Your Honor, they agreed outside and it was a stipulated order. Furthermore, I do, in discussions, often say that we can ask for attorney fees, but that's not something I can ever guarantee, and that is expressed because that would ultimately be up to a judge unless the parties agree. And in this case, they did
That's why
have
I asked, was it a ruling or a stipulated? If there's a stipulated agreement, then you're not getting attorney fees from the other side unless they stipulate or agree to pay it.
Right.
If she said, we'll ask to have the attorney fees paid by your husband, that's one thing. But if it's an agreement and that wasn't part of it, then that's not part of it. I can't substitute nor permit either party to substitute something that's not in there. Judgment per plaintiff, $1,758.96. What are your court costs?
$162.86, Your Honor.
$1,921.76. Thank you.
See, this one interested me because if you're a single mom and you're disabled, you don't have to pay certain bills. I didn't know. What other bills do I get a free pass on?
Thank you, Your Honor.
Randy Wise Motor Cars versus Michael Kevin Johnson, C24E3302 SC. It says there's no service. I don't think that's correct. Please state your name, Director.
Brent Edwards.
Brent Edwards.
Yes, sir.
Next to you is,
Excuse me?
pardon me,
This is, yes, sir.
your name.
Oh, okay, Bill Austin.
Okay, Bill, thank you.
Yep.
And you, sir, are,
I am the servicing technician on the vehicle.
your name, sir?
Michael Johnson.
Okay, let me advise both parties that either party, before we start, can have this matter transferred out of small claims into the general division of the court. If you elect to remain in small claims court, you give up the right to have an attorney, appeal the decision of the court, have a jury trial, and seek more than $7,000. On behalf of Randy Wise, you wish to remain in small claims court.
We do, Your Honor.
Mr. Johnson, you wish to remain in small claims court.
I do.
Raise your right hands. You promise to tell the truth, whole truth, nothing but the truth, so help you God.
Yes.
Yes.
Okay, why does Randy Wise feel that Mr. Johnson here owes $2,954.51?
Well, Your Honor, Mr. Johnson brought his car to us with a suspension concern in the front of the vehicle. My technician diagnosed the vehicle, found that the front struts had failed on the vehicle. We provided an estimate to Mr. Johnson. He authorized repairs. We had a completed invoice, which Mr. Johnson signed, and he wrote a check to Randy Wise Motor Cars.
Okay, I will say for the record here, I do have an attachment that consists of the invoice and what appears to be a check in the amount of $2,954 plus change, written June 20th by Mr. Johnson. Okay, were the services agreed to and completed?
Yes, Your Honor.
Okay, and subsequent to that was the you indicated the stop payment was placed on the check after the car was left the service area. Is that right?
That is correct, Your Honor.
Was there any indication why that happened?
I believe my service advisor reported to me that there were some concerns with the squeaking noise in the front of the vehicle, at which time we offered to bring the vehicle back in and re-inspect the vehicle and to determine if there was something else that needed to be addressed. And at that point, there was no effort made on behalf of the client to bring it back to the dealership to have it re-inspected. And then we got the notice of the stop for the cancellation of the check.
Okay. So the work was done, the car left your facility. A check was paid. When did you receive notice that that he believes there was still a problem?
I believe it was within a week after the repair. I'm not sure the exact date, but that's
When was the stop payment done in relation to when the car was up? With the stop, in other words, I guess my real question is, what came first, the stop payment or the?
Your Honor, I don't know the facts on that.
Okay, well, let's talk to Mr. Johnson. Mr. Johnson, what's going on here?
First of all, I have some copies of text messages between me and the rep that wrote this up.
Let's look at them.
Yes, this is just for you. I have my own copy.
Okay,
These are actual text messages. The reason for the stop payment is because I don't feel the service was done. And the reason I wrote the check is because I was left with the impression that a repair had been done.
and let me ask you this, what leads you to believe that it wasn't done?
Because I picked the car up, I paid for it, and when I got it back to my residence, it was still doing the exact same thing. Now, granted, you'll find in there an invoice for work done prior, so this is not an issue of me just not wanting to pay the amount. I had roughly about $10,000 worth of work done, had no problem with it, paid them. and it was completed. I took my car back to these guys, and I was specific in the Squeak. When they called me and informed me of the cost, I asked specifically, was that going to take care of the squeaking and the creaking that was in the front of my vehicle? In the text, you'll note, and she told me over the phone, my technicians didn't see, visually, didn't see anything loose, and they didn't hear any squeaking. I've been dealing with shops, and I'm a sort of mechanic myself on occasion, and I know when you test a car, you're going to test drive it because I paid for a diagnostic. And I don't feel like that diagnostic was done because they could have simply pushed down in the front of the car and they would have heard this squeak. So for them to say, after I get my car home, I'm backing out of my driveway and there it is again. Now, mind you, this is a car.
Let me ask you this, why didn't you take it back to them and say, hey?
I really didn't trust them at this point because the first thing I thought of is, let me check in my trunk if they gave me my parts back. They had not returned what they said they had replaced. There was none there. This is 4 days later. They said, well, we can return your struts and we can show you the reason why we replaced your struts. But when I spoke with her and she said it was the struts, I asked, was that going to fix the problem? Are they going to take care of the squeak? She says, the struts are your issue. Period. And that's the reason I paid them. So when I pay them and I get it back, I feel like I'm paying for something they didn't do because it was as simple as driving the
Somebody
vehicle.
else do it.
I did. I had that receipt in there. I took it to Muffler and Go. I found another foreign car dealer because I'm real picky about who works on my car. And I told them the same thing I told Mercedes. I have a squeaking, creaking in the front. The car drives like it's not even on it. It drives like being on a cloud. It's a really nice car. And so the struts being replaced, I don't feel like they needed to replace those struts because my car drove exactly the same as it did outside of that creaking. Took it to Muffler and Go to explain to them what had happened as far as the squeaking, and they said, oh, that's pretty common with this car for the age and the miles on it, and here's what the problem is. And he pushed down in the front, it was there. So for her people to say that they'd be happy to bring it back in to check it, that's what I paid them the diagnostic for the first time.
Well, let me stop you right there. Mr. Either one of you guys, Mr. Austin or Mr. Edwards, was there a diagnostic performed on this vehicle?
Yes,
Okay, what's the diagnostic consist of?
it actually consists of a actual road test, first of all, just to try to hear it. Okay, and then after we didn't hear it, we actually lifted the car up on the rack and actually inspected everything under the vehicle.
Is there some kind of diagnostic tool
No.
that says there's no
No.
such thing?
No,
What kind of car is this, Mercedes?
It's the 2011 Mercedes E350 Cabriolet. It's a convertible.
Okay. You said once you did a road test and you put it up on the
on hoist,
hoist. And did you do the work or somebody else?
I did the work.
Okay, and what did you conclude or are you, first of all, you're a licensed mechanic?
Yes, yes,
Okay, how long you been a licensed mechanic?
over 30 years,
Okay. With Mercedes?
since 92 with Mercedes.
Okay, that's. Was an elementary school. Anyway, so would you conclude or would you find or what's?
Well,
We're here.
actually, we actually never heard his noise, one. Actually, even after the road test or actually up on the hoist inspection was actually fine. Actually, we found the struts actually faulty on the front. Okay, so actually, thought actual process there was, okay, we can't hear his noise, but actually, we actually know that we have a problem with these struts. So, actually gave him an estimate on struts, and he authorized it, and we put those on.
Okay. Did you ever hear the vehicle after it left your facility?
It was actually actually a road test was actually done actually after the repairs, yes. Still actually heard actually nothing, and then that's it, never actually seen it after.
Did you have a discussion with Mr. Johnson about it? That you didn't hear it, but he heard it maybe?
I did not, my actual advisor did. So,
Did you advise somebody there?
No, I spoke with, I guess who he calls the advisor. She's the young lady who brings them in and she writes everything up. But just the point of fact, the car mechanic in Fenton that works on foreign cars had no problem finding it. And you'll see in their repair report, they actually found that the control arms were bad. They also found that the bushings were loose. That was on an inspection that they did. They repaired it. I haven't heard a squeak since. And prior to paying for it, I did speak with Andrea. You'll see it in the text. And I explained to her my dissatisfaction that I had paid this money. And I don't feel like they actually did an inspection because they could have literally did like I did. I back out of my driveway, there's a slight slope. And I explained this to her when I dropped it off, how and when I heard the squeaking, creaking. And if they'd have done what I did, and I explained, here's how it happens, here's when you'll hear it, it was audible. It wasn't hard to find. And I know he says he put it on the hoist, etc. But in her text, you'll see they didn't touch the car. She says they didn't see any loose parts and they didn't hear any loose parts.
If it was so easy to find and it was just a matter of pushing down on the front of your car, like you say you did, why, when you got your car back in their lot, while you're still there, why didn't you just give it a little oomph and see if it squeaks? I mean, if my main concern was that when I pushed down my front of my car, it went, when I got it back from repair, I'd be out in the front lot going, before I drove off.
I'm not confident that they were going to, I wasn't confident giving them the car back, honestly. Because once they had it in their possession, I'm sitting in the waiting room. I don't know what these guys are going to do. I don't feel like they did it the first time. And for them to offer to come a second time and do what I paid them to do the first time just didn't sit well with me. I did not find my so-called replaced parts in the trunk of my car. They weren't that large. They're not big at all. They should have been with the vehicle. It's 4 days later. They say, well, we can show you your struts and the reason they were in place. But a shop of this size, I can't believe they're going to have these 4 days later. Also in that text, you'll see where they were rushing me to pick the car because the lot was full. So being full, I don't see where they're going to be holding on to my struts 4 to 5 days later.
The car lot was full. Not the back room, not the mechanic shop. The car lot. This guy.
You got to hold on, you got to hold on to building.
72 hours, Your Honor. Yes.
How long?
72 hours. So.
And they should have been returned to me because they weren't too large for me to actually carry. So for the front of the vehicle, it's a small sports car. They're not that big.
Is there a reason they weren't returned to them?
The size of this, they're about 36 inches in length, each one of them. They weigh probably about 15 pounds each. They're greasy, oily. A lot of our Mercedes-Benz clients don't like having those parts back in their cars. We've received a lot of complaints over the years. So we did hold on to the parts. I still, in fact, have the parts.
Still have them?
Yes, sir.
Something wrong with the struts or not?
Yes.
oh, yes.
What was wrong?
The actual actual charge in them was actually empty. They are just nothing now. Empty. So,
Are they the original struts on the vehicle?
yes, sir.
So from 2011?
Yeah.
How many miles you got in the car?
I'm not sure. I'm up at about,
Like, how many miles did you have when you took it to them?
I believe when I took it to them, it was in excess of 150,000 for sure.
Okay. You know,
I did offer, I'm sorry.
go ahead.
I did offer to pay because I also had an A service that was due and that they did. And I told them I will pay for what I know they did, what I feel they actually did. I didn't have a problem with that part. It was just these so-called struts. Because again, they may say, well, the struts were X, Y, Z, but if that's the case, I would feel literally every bump that I hit. My car drove exactly the same and still drives the same as it did when I dropped it off. I am not convinced that I had a problem with my struts. And had they done the inspection and also found the struts. I would have had an option at that point to say, well, I'd rather do this in this order. I'd rather have this done first and then I'll do the struts. That wasn't the case. That I can't see how they missed it. I could literally push down on the front of my car and I could hear that squeaking, creaking. The other guys had no problem finding it.
How much did the other guys charge?
It was a little over $2,000, roughly about the same thing they were charged. It's right on the receipt there, Muffler and Go in Fenton, Michigan. And again, they didn't, and just as a note, when I did speak with Andrea, I just happened to mention, I believe it could be my struts. And I feel they went straight to that because of what I mentioned, I thought it might be, as opposed to actually doing an inspection on that vehicle. I had paid for a diagnostic. I don't feel like I got one.
In any civil case, the party brings the action has the burden of proof. In this case, Randy Wise Motor Cars is suing Mr. Johnson here for 2954.51, which represents the amount of a stop payment check that was written by Mr. Johnson for services that were provided by Randy Wise Motor Cars. Mr. Johnson asserts that he doesn't believe that they correctly diagnosed the condition of his car, which left him in the same spot he was in when he came in there. There was squeaking, creaking noise in his car that was subsequently fixed by another facility for over $2,000. Randy Wise asserts that the struts were, that the work they did replacing the struts was necessary due to the poor condition of those struts as a result of the mileage and age of the vehicle. There was an agreement. The agreement would provide certain services they were provided. Check was written. That's an indication of acceptance of services that were rendered up to that point. The stop payment, you owe them $2,954.51. I won't award any court costs on it, but you got to pay that. I haven't heard any either, other than the fact that you're asserting, I don't think the struts needed that work. I don't have anything else to help support that. I'm the rule in favor of the plaintiff by the respondents, the evidence standing. Thank you very much.
Thanks, Ron.
Thank you. Thank you, Your Honor.
Yep. Dennis Davis versus Pro Green Lawn Care. Okay, this is, you want to state your name for the record?
Dennis Davis.
State your name for the record.
Oh, Bernard.
It's apparently had been here before,
Right. Yes, sir.
and the default judgment was set aside. Five and opposed. So we're back to the beginning again, right? Okay. Before we start, let me advise both parties that either party can have made it transferred out of small claims into the general division of the court. If you go into the general division, or if you elect to remain in small claims court, you get the right to be represented by a lawyer, have a jury trial, appeal the decision of the court, seek more than $7,000. Mr. Davis, you wish to remain in small claim?
Yes,
Mr. Reeves, you are, what's your relationship to Pro Green Lawn Care?
I know. It's two different REs.
Okay.
One person.
On behalf of Pro Green, you wish to remain in small claim?
That's correct.
Raise your right hand, promise to tell the truth, whole truth, nothing but the truth, so help you God.
Yes.
I do.
Mr. Davis,
Yes, sir.
why do you think Pro Green Lawn Care owes you $6,000?
Okay, I'll read this for you. Bernard Reeves, Pro Green, claimed to be an expert landscaper and architect. We contracted him to spread mulch, pea gravel, reinstall pavers, and spray for weeds. We purchased the material. After installation of the mulch, he sprayed it for weeds. His first application on July 31st, 2021, I witnessed Bernard with one of his workers mix a chemical with an unlabeled container with water and a sprayer and then apply it to the mulch. I asked him what the chemical was. He was not able to provide a complete answer, saying that it was some good stuff that he had purchased from an Ortonville feed store. He stated that he had a labeled container at his barn and would text the picture to me. Later, I contacted him several times requesting him to send me a picture. He again stated he would text me a picture. He has never complied with the request
Why do you think he owes you $6,000?
because he killed 8 bushels and a tree with the spray.
Okay, so his company came out, they sprayed your bushes, and you said that that spray killed the bushes?
Right.
Okay. How do you come up with $6,000? How do you calculate that number?
I contacted a number of people. They gave me a bill. I paid for it for removing the bushes. Then I had them cover some of the grass areas where the tree was and prep the ground because they still had from the removal of the tree. I had to pay for that. They took up the bark and put dirt back in. And then I had I got a list of stuff here.
You just gotta get to the point here. Like why is he owed $6,000?
For replacement of the bushes.
How much did that cost? I mean, this has gotta add up to $6,017 before you
Okay,
can
that
prevail. So if you can't do that, you're not gonna win.
I can do that. Supply and install 6. Okay. Shrub removal, that was $1,575. Supply and install 6 hues, 30 by 36, and 2 gold junipers, 40 inches. That's $2,400. Supply and install 5 yards of natural shredded mulch, $220. Where the tree was removed and stumped, clean up and haul away the grindings and put topsoil down and reseed and fertilizer, $375. Cut down and grind the stump, $600. Tree replacement, 14-foot tree, $770.
What's the tree replacement?
A pine tree that was 14 feet tall,
How much was it?
$770. That's from Baldwin. That's for the tree and bringing the tree, digging the hole and putting the tree in the hole.
Did he spray the tree?
He sprayed around the tree within the drip area of the roots of this tree. And the same thing he did with the bushes. He sprayed around the bushes, close, right on next to the bushes.
Did they die as a result of the spray?
Yes,
How do you know?
Okay, I'll back up the statement here. In May 2022, we noticed that 8 of our bushes and 1 spruce tree were turning brown and losing needles. I have the pictures here and I can show you those. I contacted a horticulture expert, John Berry, at Advanced Tree Service, who identified the problem as that someone that had sprayed around the bushes and the tree with an incorrect herbicide.
Can someone get this guy a teleprompter, please?
He had seen this problem many times in very inexperienced landscapers. The damage did not appear until next year, April 2022, till the first growth was a characteristic of.
Do you have some document there that has the numbers next to it, like an itemized statement?
For what?
You're suing for $6,000. I'm not worried anything.
Well, I got it right here,
Proof that you did it.
all right here.
All right, thank you. Mr. Reeves, your response?
My response is I object to that as well, because the claim that which arose, that he said is arose, was 7/21/21, and it was filed 7/31/24. So it's based on the jurisdiction, the MCL 600 585. the statute of limitations is 3 years. So it's invalid. So
When did this all happen?
Okay, I'll give you a spreadsheet here of the dates and timing. The first application of the spray was on 7/31/21. The problem became visible almost a year later, 6/1/22. Okay, and I filed on this September 18th, 2024. I could not possibly have a complaint and file for a problem that was not visible until it was, visible. And that was 2 years and 3/10, 2.3 of a year for it to become visible, which is in the 3 years.
All right.
Not
thank you.
granted,
Thank you. Mr. Reeves, what else?
also too as well, I say, so I did the service, we got 17 yards from rock bottom. We did the 3 yards of peak gravel, and it was a 1 day, it was a non-contract. We did the service, we applied it, we wrote the check. At the end of the day, at the end, when I was going to my truck, he said, "Hey, Bernard, can you spray?" I said, "Absolutely," which I do for my clients in Kirk Ridge, the weeds in the crevices of the driveway. And that's what I did. And it was Roundup that I purchased at Ace Hardware. And also too as well, that was it. So the service was, I did it. I did the 17 yards and stuff.
How much you get paid for your service?
It was 17, I charged for the material, the 17 yards and the 3 yards of pea gravel. It was, so it came, you wrote a check for 1,700.
Mr. Davis, is that right?
No.
You paid 1,700?
no, we paid 1,800.
How much
And on the invoice here,
did you pay?
pardon,
How much did you pay?
1,800.
Okay.
And I disagree with saying that part of the contract was to spray for weeds. He wrote, we came out with this barely visible.
Can I see that?
Yeah. I had him write down, he didn't have it on there, he wrote down the weeds. He was supposed to take care of the weeds and spray. As part of the contract.
Okay. Was that Mr. Reeves? Anything further, Mr. Reeves?
All I would say is that I would, ask, so, with the section, with the jurisdiction, 600-585 is to be, it's not valid and to, close as far as the jurisdiction to, dismiss. Motion to dismiss.
In a civil case, the party brings the action as burden of proof. They have to establish your case by the preponderance of the evidence. In this case, Mr. Davis is asserting that he retained the services of Pro Green Lawn Care LLC, and paid them $1,800 to do various items, including spraying around bushes and a tree. It asserts that as a result of that, that caused the death or destruction of the bushes and the tree. And as such, he's got additional expenses. We did this earlier and came up with a number of $2,700.
Well, that was because it said at that time what I had paid. Since then, I paid the $2,400 to get the bushes installed.
The statute of limitations claim is not valid. Therefore, I grant the amount that he's requested, $6,100 plus court function. Well, am I going to work? $6,105 against $6,017 against Pro Green.
One other request to the court, please. Well, Bernard, Bernard has not provided his present residence address or the rest as an address of his so-called barn. He has not provided to me, he has not provided to you as a court.
Well, he's not required to at this point. If there's some issue about payment of the judgment, you can always come in and do a creditor's exam or request that.
Okay.
But at this point,
But he falsified documents to you.
well, that's, I don't know what to do.
Pardon?
I love how the judge just waves him off at that point. He would be a nightmare neighbor. Anyone who is that particular about their lawn, like they probably have a specific type of grass in their yard, and I bet it has the name blue in it. And I'm not saying that he's wrong, by no means, because landscaping and all of that, you know, keeping the yard pretty and the bushes and having, you know, trees that means a lot to him, and you can tell. And that's expensive. Having a pretty yard is an expensive hobby. Dude needs to pack up and go live in an HOA where that is completely acceptable. Well, probably someone who lost a 14-foot tree, but I'm sure that tree he had been growing for a very long time. I'm sure it didn't start out 14 foot when he first got it. Yeah. They usually get them when they're like 4 feet-ish. And when they're light enough and small enough to plant. But my guess would be that he was trying to replace with exactly what he lost. So he lost a 14-foot tree. He wants to put a 14-foot tree there because he's probably thinking that for the lawsuit, it has to be equal. That would be my best guess. Or he is so anal retentive that he just has to have exactly what he had. And that might be true too. Oh my gosh, Shane, thank you. That's 4. I only set the goal of 5 tonight. It's something new YouTube is doing with trying to encourage super chats. And the YouTube's goal was 10. And I'm like, they don't know how big my crowd is. I get like 30, 35 people a night. Yeah. So yeah, I took it down to 5. Well, it's better than working in the graveyard. But yes, I agree. And you have a great point. And there's no way to know. There's no way to guarantee that. And that is the biggest concern with moving trees of that size. Because typically the roots are 1.5 times the height of the tree. So if you have a 10-foot tree, you have a 15-foot root system. So yeah, that's yeah, and he would have needed a lot of heavy machinery for his. I know that wasn't the most interesting case of the decade, but the just particularity of that old man just got me. And he had a spreadsheet. Of course he did. He did. Hey, maybe that's why they're pushing him. I still prefer my Cash App and PayPal and Venmo chats. And those ones I get 100%. I even get 100% on the Buy Me a Coffee. But I'll credit those too, but you know, it is what it is. I'm still gonna court crawl with you guys. We almost got there. We got 4. That's good enough for me. I'm a horseshoes kind of gal. It's close enough. Oh, thank you, Mortimer Duke. Oh, I love you even if you were tardy. Yeah. Oh yeah. I've seen some of those neighbor wars over plants and trees and things. And it's gonna it I guarantee he's gonna have it. He's gonna have some. If he hasn't already. Isn't he though? I think you're right. I really do. I think you're right. Don't you dare. I need you. It's like at the end of the labyrinth when when she's looking in the mirror and then Hoggle and all the other guys peer behind the bed. If you need us, I need you. Sometimes for no reason at all. Yeah, it's even really difficult in plants. Just typical, you know, tomato plants to take root and stuff. Like, sometimes they just die because they're going to die when you're messing with roots. Yes, Discord is fun. Discord is so much fun. We really should do a movie night. We haven't done that for so long. Shane mentioned it, and I was like, yes, we need that. I mean, I'm not big on movies, but I'm big on hanging out with you guys. We all know that. Discord, that cord. Here a cord, there a cord, everywhere a cord. Farmer Morty had a cord. E-I-E-I-E-I-O, E-I-E-I-E-I-O. Come on, T-Birds, let's go. Extension cord. Was it torture for you? I feel like this is something that's already happened. Hey man, as long as I have my phone cord, I'm happy. A sus cord? Sus cord. I'm scared to ask. Should I know that one? I'm going to assume you mean the game and not what the word really means. Strike a chord. Harpsichord. Oh, then we're right on track. I love you, Lisette Panette. Take Morty with you. He was going to go back to bed. And I think if you just take him by the hand and lead him over to the lurking corner, y'all get along just fine. It's not necessarily bad. Infants do it all the time. Yes. Thank you, she's a maker. Thank you for reminding them. Now, Mortimer Duke, you go with Sir Philip and the two of you have fun playing together, but be nice. Oh, gosh, you guys. Of course you can. Like I could stop you. I'll probably not be much help there. You're just gonna have to close the whole stream down because I'm gonna put it up on the screen so everyone can know what Farkle means. It's a delightful game. I don't know why they chose that name. But the commercials are on point and hilarious. The commercials for Farkle are people just going around going, like a kid will walk up to his parents, Dad, I farkled. Or Mom farkled. Grandma farkled. There was even talk of when I had the merch store up, there was even talk of making baby onesies that said I farkled and then having dice on it. It's so much fun. But really the best part of it is all of us together, like shooting the breeze. Because that's the best part of every day. All right, I am going to look for something to watch because I need to run to the little girl's room, and I can't just walk away. I need to, put something on to entertain you guys. Oof, I'm scared to put that one on. I'm surprised they even have that still up. Thurston County DV is up still. Let's see, Winfield is up. I always liked that. They've got a cranky old judge too, but he gets kind of gets kind of so he's got to be edited. All right, I think I found one. Hopefully right where they belong. I am going to put on Lake Forest Park because I like that place. And they usually have decent stuff. So I have no idea what we're gonna get tonight. If that's boring, we'll find something else after I run to the ladies' room. Okay, I can't see chat at the moment, but let's get past all of the hello judge niceties, blah 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 blah. Ooh, she looks like she could be entertaining.
Thank you.
Thank you.
Miss Kelly, it's okay to turn your audio and video off for now until we get started. Thank you.
Thank you.
Oh, it's not her turn yet. Okay. Fine.
God. All right, I see we have Miss Bell here, Mr. Bakari here. And then, let's see. Miss Alderson is in a breakout room. Okay. All right, Judge, I think we can probably take, if Mr. Parent is available, because that's going to involve the public defender as well, we can take the Bakari matter.
Take the Bell matter.
All
She's
right, so
right
we are
there.
on the record. This is our afternoon readiness hearing. Today's October 30th, 2024. And this is a remote hearing. We are live streaming to YouTube to maintain our open courts. And we are now addressing Bakari 3A07-36614.
Good afternoon, Your Honor. For the record, my name is Mark Blair. I hope to be the attorney of record in this case. I have filed a notice of withdrawal and substitution that has been signed by the public defender, so I don't know that he's necessarily required to be here. It is, of course, up to the court to allow me to substitute at this point. It's my understanding from my brief conversation with Ms. McDonald that they're not objecting. I'm hoping to set this on to pretrial, and then if that doesn't work out for a resolution, immediately go to trial. I don't intend to delay this matter any further. I understand that was some concern at the last attempt at substitution. I can assure the court there won't be many delays from me.
All right, so I see that Mr. Bakari is on the Zoom hearing. I will, Mr. Bakari, just go ahead and activate your audio and video if you will. So while we address your matter, I'll hear from Ms. McDonald because the court had denied the prior request unless Mr. Burke was prepared to go forward to trial because there was a concern with the victim and the number of witnesses that had already submitted to interviews and the amount of work. And so I had denied the untimely request for substitution of counsel. Ms. McDonald, what's changed?
Yes, the only change in terms of the city's position is that we did, in confirming for trial and getting everything ready for today's hearing, did learn that the alleged victim does have, she's a medical professional, and excuse me, is going to be out of state for part of next week for a medical conference that she has to attend. And so that kind of puts a little kink in her availability for trial next week. So I can no longer state that a continuance would not be in the best interest of this case to give her the opportunity to be able to appear for that rather than have to try and cancel her speaking engagements. So that would be the only change in the city's position. I have spoken with Mr. Blair. It sounds like we are destined for a pretrial with hopefully a resolution on this sooner rather than later. And so based upon that conversation, I think we're in a bit of a different position than we were last week.
And I would just add, Your Honor, given that I had an outreach from the public defender. I'm not planning on having to re-interview people. I'm assuming they did their job well. So that shouldn't cause a delay. And I do look at CR LJ 3.1 Section E. My understanding is the two factors for the court to consider in granting is whether there's good cause, and secondly, whether another attorney has substituted in. So one of the two factors been met. I have substituted, I've been retained, I've been paid. So as far as good cause, I think from what I can see, there seems to be a bit of a breakdown in the attorney-client relationship with the public defender. And so for those reasons, I'd ask the court to grant, along with what Ms. McDonald has said.
All right, I see that Mr. Perrin has signed off on the order. And I don't have an issue with allowing new counsel to substitute in. The problem was that Mr. Bakari had waited for such a lengthy amount of time that it then caused a issue.
Understood.
But now I'm hearing that the city is not objecting, and so I will allow the withdrawal and substitution of counsel, and I will grant the request to continue.
What pretrial dates are available, Your Honor?
No, I threw out my paperwork from the morning calendar. I wasn't looking at that. So let's see. Are you thinking this is going to go on the December or January term?
I'd like to keep things moving along. What is the December term? I just want to make sure it doesn't conflict with a family vacation.
It would be the 10th of December with readiness on the 4th.
And so the 10th would be an actual potential trial date?
Yes, that would be
That
the
works for me,
Tuesday
Your Honor.
start of
Let's put
trial.
it on that and then get a pretrial in November.
Okay, and there'll have to be a waiver of speedy trial because it's currently 11/25.
I'm happy to do that, Your Honor, if the court would allow me to do that orally, or I can do it by end of day. I can draft it.
Orally is fine. Orally is fine.
And I'm asking on behalf of my client, I have full authority to waive and ask to extend speedy trial to cover my request for continuance.
Okay. Can we commence speedy trial at the next hearing date?
Yes, Your Honor.
Okay, that would be a pre-trial. And let's find a date that works with your calendar.
Thank you, Your
So
Honor.
it's basically going to be any Monday towards the end of November. You can have the 18th or the 25th.
18th is fine, Your Honor.
Okay. So let's continue speedy trial from that date. Set it at 2/15/25. Jury trial will be 12/10. That's at 9 a.m. Mr. Blair, we do readiness via Zoom like today at 2 p.m. the Wednesday prior.
Great. And I assume the defendant needs to be present for readiness?
He does.
Okay, thank you, Your Honor.
And for the pretrial hearing, we will send notice out to your attention.
Excellent. Thank you, Your
All
Honor.
right, thank you.
Good to see you again.
Right, and then I think that Miss Ebert is in the breakout room with individual, and Mr. Parent, I haven't had a chance to speak with him to see what he wants to do on the Bell matter.
And I just learned that Ms. Bell wants to talk to me again before we go on the record, so I'm gonna break out with her.
Okay.
So Ms. Bell, will be room 4. There you go.
Mr. Smith is here in the lobby.
Yes. Oh, if he is available, we can take some of his, but
I can talk to him. I'll let him know.
Thank you.
Thank you guys. I am so sorry. Yeah, I have no idea what the heck. It and the part that makes it so strange is that it doesn't match the top and bottom. Like, you know, we talk about, does the carpet match the drapes, and in
He'll
this,
be with you momentarily.
the drapes don't even match the drapes. Yeah.
Doing what I want. There I am.
Yeah.
Do they hear it? All right, good afternoon, Your Honor.
Good afternoon.
You're gonna stay home. All right, I'm here first with Mr. DeWitt.
Okay.
We're here for readiness, and I think we're gonna agree to a continuance of a month to the next readiness calendar. Is that my understanding?
yes.
Okay. So we're not objecting to that. We would ask the court to just exclude the time.
Let's see.
All right. That's 4A003864.
Lake Forest Park, Washington. And it's usually quite entertaining.
We can do an excluded period. We currently have speedy trial through December 14th. Essentially, Your Honor, we have defendant is on deferral in 2 other courts. One court has agreed to enter into a global resolution. It looks like Mr. Smith would like to reach out to the other.
Okay.
So that would be the basis for this. I think we could set it in the December term without even messing with speedy if trial week starts 12/10 and our expiration is 12/14.
I don't mind if the city doesn't mind, as long as we're still in speedy, I'm happy. I'm fine with it.
Okay, so I had in my notes speedy was 12/16/24. So we can do readiness on 12/4 at 2 p.m.
On Zoom.
And yes, on Zoom. And then the jury trial would be 12/10 at 9 a.m.
Nobody wants to.
And you're not asking for an intervening pretrial. We'll just readdress this at the next readiness hearing.
Yeah, and if there's an issue that comes up, I can set a hearing.
Okay, but you're thinking global resolution is.
Yeah, that's what I'm thinking you want.
Okay. All right, that sounds good. Mr. DeWitt, thank you for appearing today.
Thank you.
And good luck getting everything resolved.
Thank you.
And we'll
Last
take
on the
care of it.
license, that's
Yeah, he
good.
does have his license back, so we're in the right
Had it
way.
back since day one.
That's fantastic. All right, so I'll see you in December.
Wisconsin.
You know, I also had Miss Sassnet. I thought she was gonna zoom in. I just spoke to her, an hour and a half ago. I would ask, well, City and I have come to a deal where the Sassnet will plead to her Kirkland case, and after she does that, this matter will be dismissed. My clients agreed to that. She also is working on felony. I don't know why she's not here. I've had good contact with her. I told her on the phone that we would set this a few days after her Kirkland matter. I would ask her to waive her presence under those circumstances and just set this for disposition. Oh, I guess it's 12/2. So whatever we have after 12/2, I think Kirkland's next court date is 12/2.
I'd ask for a bench warrant.
I think our speedy trial is December 3rd.
You know, I don't mind excluding the period. The intention is to take advantage of the global.
Ms. McDonald?
And you said you had contact with her today?
I just spoke to her an hour and a half ago. I said, I thought she was going to zoom in. I told her what we were going to do. I told her we were going to set a hearing a few days after the Kirkland hearing, and that we do a 1-for-1, and she was all on board, and I just don't know why she's not here. She's well aware of what we're going to do. She's well aware of her plans. I'd ask the court to set this hearing as soon as we can after the December 2nd, and for most likely a dismissal.
I would ask that we find an FTA, Your Honor. I don't necessarily have a problem. If we find an FTA and set it after the December 2nd hearing, that is the intention of the parties. I'm just surprised she's not here today.
So I don't mind noting the FTA, Your Honor.
I'll do an FTA. I won't issue a warrant at this time. We'll resummons for a date, and we said after November
2nd.
2nd. Let's see.
It'll be God.
Can we do the 12th?
We can be.
It's a Tuesday, so just be mindful of that holiday Monday.
She had a
Well, the
key.
12th is Thursday.
Are you talking December 12th or November?
Sorry, I'm just talking December. So his turn-
December.
court date
Okay.
is
Then
the-
let's do the 16th, please,
December.
of December.
All right, that'd be perfect. And then I'm confused. Is the warrant being held?
I'm not issuing a warrant. I'm issuing a failure to appear and sending a resummons.
All right. Thank
Ms.
you.
McDonald, you weren't seeking a warrant, were you?
She just wanted the FTA.
Yeah, FTA has been noted.
Yeah, no,
So
I
that's
would
9 o'clock
want a
on the
warrant.
16th.
Yes.
I'll let her know and we'll be ready.
Okay, sounds good. Thank you.
Thank you. That's all I have.
Where'd your kitty go, lady?
I can address the case of Mr. Angel Cruz if we're ready on that. That's 3A0770665.
You?
I want to see Miss Bell.
All right, Mr. Angel Cruz, if you could activate your audio and video.
Hello.
Hi there. Okay.
Your Honor, defense is moving to continue for attorney availability on this trial, just to the December term. I mean, yes, December, sorry.
I can't read his shirt.
Ms. McDonald?
And Your Honor, I don't have an objection to that. Our loss prevention officer, who would be our foundational witness for the surveillance video, is out all week on a work trip to Nebraska, and our alleged victim has some limited availability due to some medical appointments next week. So a December term would be fine.
I share my bed with Ava and 3 cats.
Okay, and that will be with waiver?
We would ask that there be a waiver, yes, because
Yeah, I don't think we can get to the next trial term.
Yes, Your Honor, there's a waiver.
Okay, what date are you agreeing to recommence at the next hearing date, or how are you wanting to just continue 30 days excluded period?
That would be fine with us.
Is that agreeable to the city, extending speedy
That's-
trial
that
until January 3rd?
So let's see, if we are October 30th and we're setting it to December 4th, that would be 35 days from December 4th. So what date was the court thinking?
Oh, I was thinking the 3rd, but we should, if you have your calculator, 35 days from, I have December 2nd.
So December 2nd would be the end of our current expiration. So the 35 days would be tacked on starting at our next court hearing.
Okay.
So that's why it was, yeah.
Okay.
So 35 days from January. What date was that?
Her internet's awful.
When are we resetting the date? Sorry, I missed that.
Oh, we're setting the actual trial. I think they're asking to set it on for December. So readiness 12/4.
So let me see.
And the bottom two have the same filter, and it's driving me crazy.
Trial 12/10.
So 12/4.
So blurry.
And add 35 days.
At least the top two are clear, so I know it's not just, you know, that I'm
I would show January 8th would be expiration.
under the influence or something.
Okay. Speedy 1/8/25. All right, so that will be our next court dates, Mr. Angel Cruz. And are you still on Shoreline? In Shoreline on 21st?
Mm-hmm.
Okay.
Sorry.
Be looking out for your next court date in the mail. We'll send you a written notice.
Mm-hmm. Thank you, Your Honor.
Thank you.
All right.
I'm afraid that is all I'm ready on right now, Your Honor.
That's okay, because we have fast forward in our power. I bet they're saying something really interesting right now. Oh my goodness, it's a good thing I have fast forward power. It's not paused.
I'm sorry if anyone was saying something to me. Every time I move out of a breakout room, Zoom tells me my speaker is broken and I have to reset it. So I'm very sorry if I missed something there.
No, you were talking to answering a phone and we could hear you.
Oh no.
That's okay.
We were trying to tell you, stop talking. But Miss McDonald did you. We heard nothing.
Okay, good. Thank you. Yikes, I'm sorry about that. All right, I'm working on the paperwork on Alderson, and then I will go over it with her.
Okay, thank you.
Thank you.
Okay, that was funny. A lawyer's worst nightmare. Because that, like, violates so many rules. Oh. Yeah, and unfortunately, they take everything down so fast. But I have everything from today. I just don't have any of it exported, and it won't allow me to run the raw file. I have to export it and convert everything into an MP4 in order to be able to stream it. I don't think we went entirely through the, what was it, September Kansas docket that I exported for Patrick B. So like I have probably half of a Judge Webster docket, I think. Zeus must be your baby, huh? Yeah, Ava's the star of the show, but she's currently snoring. She's currently snoring behind us. Oh, yeah, fast forward. Forgot about that. All right. Come on, Miss Bell. Big money, big money, big money, big money, and stop. Hold on, gotta back it up. I did not go this far. Stop it. Quit it. Here we go.
Thank you.
Chia.
Here comes Judge.
Okay. Kelly Bell, 2A06053008.
Yep. For the record, Sean Parent from Ms. Bell. This is a defense request to continue one term with an intervening pretrial. We're pretty close to a resolution on this, but Ms. Bell just needs more time to go over the paperwork with me, since she does live out of state. And she also has a bit of a hardship getting here next week anyway, because both of her parents are, one's 85, one's 84, and she's their caretaker essentially. So for those two reasons, we're asking the court to reset.
Okay, Ms. McDonald.
Yeah, it does sound like we've got a resolution in the works. I'm just concerned, are we going to be able to get Ms. Bell back here for the resolution?
Would she need to be in person to do a plea?
For a DUI?
We would generally want that to be
Yeah.
in person, but we also, I mean, because she is living out of state, Ms. McDonald, I think we could make an exception, but I would want it to be very clear and have the ability for signatures on plea forms and JNSs.
What?
So I would be willing to have some consideration for that. I don't know if Ms. Bell is able to go to a place where she can receive documentation, print out documents, and resubmit them.
Someone moved.
I'm able to
Washington?
receive documents and print them here at my house, at my parents' house.
I'm shocked.
Would that be acceptable to you, Ms. McDonald?
It's acceptable to me if it's acceptable to the court. When are we thinking about doing the intervening pretrial?
So are we just setting this to December term or?
No, I think we're setting it to December term with an intervening pretrial. Certainly if there's no resolution at the intervening pretrial, then we would want her to appear in person for readiness. And I know that would be a little bit difficult, but I hesitate to set a case for trial again without knowing whether or not she's going to be here, given our witnesses.
All right, so what are you seeking for dates, Ms. McDonald?
I would suggest 2 weeks.
Okay, so we have readiness on 12/4.
Oh, she
trial
was.
12/10.
Them's her church clothes.
Are 2 weeks out. We could set it on the 12th, 13th, or 18th.
It's terrible, whatever it is.
Should we do the 12th?
Ms. Bell, would that work for you?
I'm actually out of town the 13th to the 16th, and the 12th, my dad has several doctor's appointments, so it would be very difficult for me to be available. But what was the third date?
The 18th.
That should work just fine. I'll be back in town.
Did McDonald's camera get worse?
Okay, so if I set the pretrial on 11/18/24 at 9 a.m.
I promise it's usually way better than this.
Looking at a current expiration, I believe was 11/18. You've discussed a waiver with her.
Yes, she is willing to waive time for trial restarting on the next court date.
So that would be 90 days from 11/18.
Probably.
set that for February
Now, is that pronounced mixuck
14th. I don't
or
have my speedy trial clock, but that should be adequate.
mixuck D?
And 214.25. And are you anticipating resolution at that pretrial?
Yes, quite possibly. I'm guessing so.
I like the first
Okay,
one
so
better.
if it's not resolved at that pretrial, then witnesses would be called and she would be expected to be present for trial on the 10th. Are we in agreement that that is what you all are anticipating? Ms. McDonald, is that what you're anticipating? Is that if there's
I
no-
would be anticipating that she appear for the readiness on the 4th so that we can ensure she's present in the state for trial the few days after.
Okay. All right, so Ms. Bell, your next hearing will be on November 18th at 9 a.m. If your case is not resolved, it's anticipated that this is going to trial 1 month out on the December 10th term, but you will be required to be present at readiness on 12/4. Okay,
You mean I would have to do
you'd have to travel to
Seattle.
Washington, yep, and be here
by
for
12?
trial. We'd have to have assurance that you were there, present, ready to go for trial. Okay, that would be on the December 4th.
Then I would stay there from the 4th through the trial date. That's a lot of hotel. I don't know.
That would be the city's request.
Well, yes, I'm concerned, Ms. Bell, that we were set for trial for next week, and you're now saying that that would be exceedingly difficult for you. If we get jurors brought in, it's a great expense to the city to do that and to line up witnesses. So my expectation would be that you would be here, and show that you're ready to go, and will be present for trial. Okay, but right now, the next hearing is November 18th. So whatever you are working on with Mr. Parent, keep that communication open with him so he can relay your position to Ms. McDonald.
Thank you, Your Honor.
Okay, and are you getting our correspondence? You're still at Mustang Crossing, right?
Yes, I am. Yes.
You'll get the updated court dates in the mail.
Thank you very much.
Thank you.
Maybe Miss McDonald is in her car and it's like steam on the
All
lens
right,
of the
so we are down to
laptop.
just Miss Alderson.
Yes, Your Honor, and I did just send into the court a copy of the plea paperwork.
Okay.
Because it's getting worse.
And Ms.
still.
Ebert, I just sent you an email with a couple of the slight changes that I added to it.
You looking at them now? Okay.
Lois,
I
I'll
see.
send it to the printer. I'm sorry, everyone. Lois, I'll send it to the printer if you'll bring the plea form to me.
I already printed it, Judge.
Oh, perfect.
Lois, she's on it.
All right.
I see the change to the agreement in the way of a $400 fine. And I see the change to the plea statement.
Yep, that's it.
All right.
So is this docket.
Let me just have a quick moment with my client.
Oh, wow, it clears up.
I'll make a record of that when you expect.
All right, I think we are going to go find something more interesting because this is terrible. I am surprised y'all are still with me. Hold on. Is this one any good? Erin A, don't let me down. No, she looks too goody
All right.
two-shoes.
So on Alderson,
You just missed
I
that.
have paperwork in front of me. Is that the paperwork we're going over?
Your Honor, I just sent an updated form. The form that Ms. McDonald sent is correct up to and excluding my client's statement. There is an updated and agreed statement in the form that I just sent.
Okay. So Lois, if you'll print out the updated version.
This is what I go through when I'm trying to find content for you guys.
It might just need to be page 7, if that is at all helpful.
I have to watch
just printed it.
terrible stuff all day to find good stuff for you guys.
All right. While that's being brought to me, since I have the first 6 pages, I'll let the parties make a record.
Yes, Your Honor.
Sorry. Go ahead, Ms. McDonald, I apologize.
Your Honor, in this case, the defendant is currently charged with the crime of driving under the influence. We have negotiated a plea where the city will be moving to amend the charge to reckless driving. And based upon the fact that the defendant does not have any prior offenses, has made the victims and the city whole based upon the restitution issues that the court was seeing, and has taken steps to get the evaluation. We do believe that's an appropriate recommendation. Upon the court's acceptance, the defendant is prepared to enter that plea of guilty to the amended charge.
That is correct, Your Honor. Caddy Bear on behalf of Aaron Alderson. We waive any formal reading of the amended charge. We do not object to that amendment. I believe Ms. Alderson is making a knowing and intelligent decision to plead guilty. I have satisfied my obligations under Padilla and Sandoval.
Good afternoon, Ms. Alderson. Is your true and correct name Aaron Alderson?
Yes.
You're 23 years old and you have a college degree?
Yes.
All right. I have before me a statement of defendant on plea of guilty to the amended charge of reckless driving. Did you discuss that charge with Ms. Ebert and understand the elements of the crime and what the city would have to prove to convict you?
Yes.
In paragraph 5 on the plea form, there's a list of constitutional rights. Those rights are being surrendered by you by entering this guilty plea.
All right, guys. I'm switching it. Let's go see Daniel Norbeck. He's always fun too. Sometimes. I better be careful what I say, because when I use always or confirmatory words, that it doesn't go well for me. It's one of those, oh, you're gonna say always on that? Well, I'm gonna show you up now and just make you wrong. That's life talking to me there. Can you guys hear Ava? Oh my gosh. She's snoring so loud. It's got to be her because it sure ain't me.
Prosecution. Then I have to wait for my computer to connect. Mr. Thomas?
Yes.
Mr. Thomas, you can have a seat right up here at this table. All right, this is file 2402582GZ, State of Michigan versus one Christopher Thomas. We're here today on a show cause. So first things first, do you have your proposed order?
Yes.
Go ahead and bring that up to me. You. And these dogs are in custody?
That is correct.
All right. And then, Mr. Thomas, so I'm not referring to these dogs all morning as one female light brown pit bull and one male brown lab mix. What are their names?
Brutus and Bella.
Oh, I don't know if I can run a dog cage.
So first things first, do we have any preliminary matters to put on record before we would start? Mr. Thomas?
I don't know what's going on.
All
I
right.
don't even know what you mean.
Then for the record, how about for the people, you want to put your name on record?
Thank you, Your Honor. Aaron Burr on behalf of the people.
All right. And then sitting at council table is Deputy Byler, right? All right. And so without any preliminary matters, we can move right to opening statements. That would be with the people if you prefer to make one.
People will waive, Your Honor.
All right. Mr. Thomas, that would be your opportunity to either make an opening statement now, wait till your case in chief, till it's your turn to present evidence, then make an opening statement, or you could waive opening statement, meaning we would just get right into
I'll wait
the
till, I'll wait.
All right. Then the proofs are with the people.
Thank you, Your Honor. People called Mr. Jeffrey Cole.
Okay, sir, you can come up to this stand here. I'm sorry, Counsel, your last name will be Burr. No.
In here? Weird.
Yeah, right there in that seat. The first thing I need to do is swear you in.
Is that
Please raise your right
real good or real
hand.
bad?
Swear or affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes.
All right, so go ahead and have a seat. Please spell your name for the record.
Jeffrey JONPOEL.
And how do you pronounce that?
Jeffrey John Poole.
Mr. Burr, you may proceed. You can either ask questions from there or swivel that podium around either way, as long as you're near my.
For better. Here. Good morning, Mr. Cole.
Morning.
What is your current address?
1040 South Stoners Drive, Plainwell, Michigan, 49080.
Okay. And are you familiar with the dogs in this matter, Brutus and Bella?
Yes.
Can you describe what they look like?
Kind of a light brown and brown color. They both look similar, like pit bulls, but 40-50 pounds maybe.
And do you recall an incident regarding these two dogs that occurred on April 27th of this year?
Yes, I do.
And can you tell me what happened on that day?
Yeah, it was early morning, and I was looking out my front window because I was getting ready to let my dog out. And I saw that these two dogs run across the street into my neighbor's yard, which I thought was odd because she usually puts her dog out, but I didn't hear the dog barking or anything. And I thought maybe they were after a cat or something that was running around once in a while. So I stepped out on my front porch to see. They both had a hold of the neighbor's dog, from one in the front, one in the rear, and they were basically playing tug of war with her.
And what's your neighbor's name?
I don't know my neighbor's name.
But it was, you knew that it was your neighbor's dog?
Yes.
And it was being, would you say, attacked by these two dogs, Brutus and Bella?
Yes.
And what happened next?
I ran across my yard yelling at them, and they dropped her and took off running.
Okay.
And her chest cavity was ripped open, and then her rear leg was ripped open, and it appeared that she had a broken leg or something. I guess it turns out her.
Oh no, guys, I'm so sorry. It's still up if anybody wants to go watch it, but I can't run that. I have too many animal lovers that are probably already in tears. Oh man, that's the difficult thing with court crawling, is you really never know what you're gonna get.
Yeah.
So sorry.
All right, so everyone is here for same thing, to be arraigned on some traffic misdemeanors. We're gonna go through these one at a time, right down the line. Get you out of here. So the only thing I would tell you all before we get started is you are able to plead guilty in front of me if you wish to. But I can't make plea deals with you. In other words, if you plead guilty in front of me, you plead guilty as charged. What I mean by that is, if what you were looking to do is you wanted to talk to someone about your case, maybe explain something away, try to get a lesser charge, something like that, that may very well be possible, but it is not possible here at arraignment. If that's what you were looking to do, you would plead not guilty today. That does mean that you'd have to come back to court at least one more time over Zoom. But that next time you come back, you'd be talking to someone from the prosecutor's office. That's who can wheel and deal with you for plea deals. All right. So we'll get started here. Mr. Walters Gates, you able to hear me?
Yes, sir.
I'm going to read this to you so you understand what we're talking about. It says October 4th of this year on East Allegan Street there in the city of Otsego that you were driving while license suspended. That means you're operating a motor vehicle while the Secretary of State has you as either suspended or revoked. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines and costs. Understanding that, do you wish to enter a plea of guilty or not guilty to that charge at this time?
I'd like to plead not guilty.
Okay. And if that were to go all the way to trial, would you like to have that trial in front of a jury or in front of a judge?
Yes.
Which one?
In front of a judge.
All right. You can continue to represent yourself like you are today, free of charge, or you could always hire an attorney if you wish to. I am going to give you a PR bond, meaning personal recognizance. You do not have to pay any money. We're essentially trusting you that you'll just keep coming back to court, but that is no driving without a valid driver's license. Is this a good address for you on Jefferson Street?
No, I do have a changed address.
All right. What is the good address?
993 US 27 North, Tecumseh, Michigan.
Spell that.
TEKONSHA. My bad.
Okay.
It was updated.
All right. So we do already have that number. You will get a next court date along with new Zoom instructions for courtroom A in front of Judge Scotchless. That'll get sent out to you in the mail, but you're all set for today. You can go ahead and go.
All right, thank you. Have a good day, Your Honor.
You too. Mr. Shoemaker, are you able to hear me?
Yes.
This says that on October 4 of this year, on 138th there in Door Township, you had a driving while license suspended. You also have a different misdemeanor for failing to stop after a property damage accident. That is also a misdemeanor that is punishable by up to 90 days in jail and for $300 fines and costs. Understanding both of your charges, do you wish to enter a plea of guilty or not guilty at this time?
Not guilty at this time.
All right, and should that go all the way to trial, we'll be looking to have that trial in front of a jury or in front of a judge?
Judge.
Okay. And so, same thing I said to the gentleman right before me, you could represent yourself for free or not, that's up to you. You can also, I'm going to give you those same PR bonds. You don't have to post any money. You shouldn't be driving unless you have a valid driver's license. Is this a good address for you on 20th Street?
Yes.
All right. So you will get a next court date. Both of these matters will be up at the same time in courtroom A in front of Judge Scotchless. That new date, along with new Zoom instructions, will get sent out to you in the mail, but you are all set for today's date. You can go ahead and go.
Okay, thank you. Have a nice day.
You too. Mr. Ramirez Vasquez, you able to hear me?
Yes, he's here. He don't speak any English, so I'm trying to translate for him. My name is Maria
All right.
Martinez.
This says that on October 4th, he was driving on US 131 and he is driving on a suspended license. So that is the misdemeanor. He also got a ticket for too fast for conditions. That is not punishable by any amount of jail time, but it is punishable by fines and costs. So he has two different charges. Does he wish to enter a plea of guilty or not guilty to those charges at this time?
Para esos, vas a jugar tu culpable o no culpable. Culpable. Yeah. Well, he wants to plead guilty for the charge of driving too fast. He renewed the driver's license. He wondered how he has to do in order to show the new driver's license or the renewed.
Okay, so what he'd have to do on that one is plead not guilty. And then when he meets with the prosecutor, he can have the prosecutor look that up and see if the prosecutor will give him a better deal.
Okay.
So he shouldn't plead guilty to anything today, even the too fast. He should just plead, if he's gonna plead not guilty on one, he should plead not guilty on both. And then he'll get to talk to the prosecutor next time. We'll indicate that there's a request here for the Spanish interpreter.
Okay, all right. Dice que no te vas a ser culpable de ninguno de los cargos, que vayas donde el persecutor, le muestres eso, y ahí él te puede dar un mejor deal.
Is this a good address for him on Kirtland?
Yes.
All right, then he will get a next court date along with new instructions sent out to him in the mail. That'll be the next time he's due on Zoom, same as today, but that next time he'll get to talk to a prosecutor.
Okay, so he's able to go tomorrow to the prosecutor or not?
No, the next date will get sent to him in the mail, so I don't even know the next date. It'll get sent to him in the mail, all right?
Okay, all right.
Thank you, I appreciate your help.
You are welcome.
It's loading, you able to hear me?
Yes.
Yes.
Okay. It's loading, this says that on August 4 of this year on North Forest Street in the city of Wayland, that you had a license, driving while license suspended. Understanding that charge, do you wish to enter a plea of guilty or not guilty to that charge at this time?
We're not guilty.
Okay, and should that go all the way to trial, would you like to have that trial in front of a jury or in front of a judge?
In front of a judge.
Okay, same thing you hear me telling everyone else, you can keep representing yourself for free like you are today, or you could hire an attorney. Your warrant will get canceled because you are in fact here today. We'll change that to a PR bond. It is still no driving without a valid driver's license. And then, is this a good address for you on Birchfield Drive?
Yes, but what if my license isn't suspended though? Suspended.
Okay, I mean, that's between you and the Secretary of State. I can tell you, looking at your license here. Yes, ma'am. You had a driving while license suspended back in 2019. So once that happens, ma'am, and no proof of insurance in 2018, ma'am, the Secretary of State will suspend your license for all that.
It's been suspended the whole time.
So you need to clear that up with Secretary of State, but you have multiple offenses. Ma'am, you were just caught with no insurance February of this year. Every time you get caught driving around without insurance, they automatically suspend you. So you do not have driving privileges in the state of Michigan. You understand that?
Okay.
You're clear on that? Okay. But that address is good for you. Are you on Birchfield Drive?
Yes.
All right. So you'll get a next court date for courtroom A in front of Judge Scotchlist, along with new Zoom instructions. That'll get sent out to you in the mail. The next time you Zoom in, you'll be talking to a prosecutor, hopefully resolve things with them, but you are all set for today.
Okay, thank you.
She got lucky.
Mr. Burkhead, you able to hear me?
Yes.
Mr. Burkhead, this says October 5th of this year on 110th Avenue in Cheshire Township, that you have a driving while license suspended. Understanding that charge, do you wish to enter a plea of guilty or not guilty to that charge at this time?
Guilty.
And anybody force you or threaten you to make you plead guilty?
No, sir.
Are you pleading guilty to this because you believe you are guilty of this?
Yes.
Were you operating a motor vehicle here in Allegan County at that date and time that I read to you?
Yes, sir.
And at that time, did Secretary of State have you as either suspended or revoked?
Yes.
So I do find that that is a factual basis to accept your plea and that your plea is knowing and voluntary. It would just be fines and costs at this point. $250 fine, with that's $200 in statutory costs, a crime victim's rights fee of $75, and a state cost of $50. That is a total of $575. I'm gonna write right on here, you have 90 days to pay that. If you need more time than that, that's okay, but you'd have to call the court and ask for you to be put on a payment plan, all right?
All right.
You are all set for today. You can go ahead and go.
All right. Thank you.
Ouch.
And that was it for 2:30. We will be back at 3 o'clock.
Oh. Alrighty. Let's see what's up in Payson. Am I still muted? Nope, I'm not. Let me check something. Ah, here we go.
Let me stand right here. State your full name for the judge.
Anthony Sobomoro.
All right, sir. You still live at Jake's Corner?
At the moment, no, not right now.
You don't live there?
No, I'm actually staying with a friend, but I can receive my mail there though.
Okay, so that's still a good mailing address?
Yeah.
Okay, so it's 57560. That's mail will go there?
Yeah.
Okay. And then your phone number ends in 3845?
Yes, sir.
All right. So the state is alleging a violation of a court order against you. That's a class 1 misdemeanor. You have the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on the 20th of November at 9 o'clock in the morning. You'll need to be prepared to plead either guilty, not guilty, or no contest to those charges. Depending on how you plead will be what happens next with the court proceedings. Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, and do not contact the alleged victim from the order. Okay. Now there's a separate matter. You failed to appear on a court date a couple weeks ago.
Yeah, that's the 22nd.
Yep, the 22nd. What happened?
I couldn't make it, and then I had no way of calling, and yeah, I just had no way of calling. But
Why do you have no way of calling?
I have no service on my phone right now.
And no one else that you know in your entire life has a phone that you could have called?
Yeah, nobody had a phone.
All right, I don't accept your reasoning. So just so you know, your reasoning is not satisfying the court at all. So what you're trying to tell me is you had no way to contact the court since the 22nd or before to say you couldn't show up.
No, I thought I was going to be able to show up, but I didn't have a way to get up here at all.
That's not what I'm addressing, whether you were able to get here or not. You didn't. It wasn't important enough for you to contact the court.
So yeah, it was important for me, but I didn't have a phone to contact at all.
And you had no way to get to one or nothing between now and that date.
Not really.
Yeah, the court doesn't accept that. So I've got to make it important to you, sir. You're here on a misdemeanor violation. You've got this other situation that we had scheduled. Other people were here waiting for you, but not you. So it wasn't important to you. So we wasted all of their time. So I got to make it important to you. How do I do that? Keep you in custody?
No, I mean, I have a job at work. I'm working now.
Yeah, but it can't be the priority. The priority is when you're ordered to go to court, the job doesn't matter. You have to go to court.
Yeah.
All right. If I release you on this, I need you to walk directly across the street and come over here and get a new court date, and do not fail to appear to your new court date. Don't give me any of that terrible reasoning that you just tried to do again. Make it more important to you than those terrible excuses that you're trying to convince the court.
Sure.
All right. So this court date is November 20th of 2024. I'm ordering you to be in court on that date to give your plea. I'm also ordering you to max pretrial services. So what that means is when you're released from custody, which I'm going to do, release you on your own recognizance with that information that we just discussed, and with the promise that you'll appear on the court date and follow these release conditions. Once you're released, you need to contact the probation department. You're not on probation, but you are on release services. So they're going to monitor you between now and your next court date, so on and so forth, until the case is adjudicated. If you fail to contact them or do their requirements, they'll notify us that you're not compliant. We'll put a warrant out for your arrest and have to take in consideration not releasing you. I'm trying to give you the benefit of the doubt, but I just need this to be important to you as it should be. Okay. All right. So you can comply with those conditions that I provided you.
Yeah.
All right. You'll have the name and phone number of the person that you need to contact right when you're released. And then I need you to cross the street and come to the courthouse to get your next court date that we can reschedule.
Okay.
All right. Do you have any questions?
No.
Okay. We'll see you here in a few minutes. I'm releasing you on your own recognizance then.
Thanks, sir.
You bet. Have a good one.
All right.
I
All right, so you can
can't.
send this to me.
Okay. You betcha.
I can't
Talk to you later.
believe
Bye.
the judge let him get a PR bond.
JD Vance sat down to record.
I just can't. I couldn't find a phone in that long of time. That's such a horrible excuse. And yet the judge, he didn't let it fly, but he let it fly. Ridiculous. All right, let me... One more. I just got to find it. I don't know yet what we're doing, but we'll do one more. Oh, boy. See, and I gotta struggle with, so many of these have terrible audio in the courts, and I know that they do. All right. Lakewood's usually pretty good for audio. All right. Hi, Sobe Liz, sweetie. So good to see you. Yeah, I think you're right on that. I got excited at first, you know. I'm like, ooh, the judge is going to hold him accountable. The judge let me down. Thanks, Arizona. Do, 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 do. All right. Just gotta zoom forward. No pun intended. My goodness. Name that.
Yeah, and
area.
we can readdress it on the record on Friday as far as appointment. Preview will be, you will be appointed on Friday as well.
All right. The judge forgot to turn the camera to the court, and it's currently just set on Nisqually. So she's for 30 minutes doing court hearings with the camera only on the Nisqually prisoner. That's funny.
Okay.
If defense counsel at table could be excused.
Yep.
Thank you, Your Honor.
You can look later if you want to see that order. And once it's prepared, I'm going to do just what I said I'm going to do.
I appreciate it. Thank you.
All right. Take care, folks. And don't apologize for being difficult. You got to be difficult. Both sides have to be difficult. I spent 20 years being very difficult. Take care. Take care. All right. You ready on Nisqually?
Yes, Your Honor.
Okay. Great. You can call your first case and I'll get Nisqually's calendar pulled up here.
Who is in Squally right now? Could you state your name? Alicia Armstrong. Okay, perfect. This is Alicia Armstrong, case number 24L0694 on for arraignment.
Great. And Alicia Marie Armstrong is your true and correct name? Is that correct?
Yes.
And your date of birth, April 26th of 1985?
Yes.
And you still reside or receive mail at the 5622 address in Lakewood?
Yes.
And did you have an opportunity to review the constitutional rights that attach to the arraignment?
Yes.
Did you have any questions for the court about your rights?
No.
Okay, I'll turn it over to counsel.
Yes, Your Honor, this is Sophia Arnold, Rule 9, for the record, present here today with Alicia Armstrong. Defendant has received the city's criminal complaint. Defense will waive a formal reading and ask the court to enter a plea of not guilty. Defense will also like to stipulate to probable cause for today's hearing only. The defendant has been advised of her rights at arraignment, and after screening her, she does qualify for court-appointed counsel. We ask to be appointed to her case.
All right, thank you. And I will, pursuant to the record made, I will do a direct appointment to the public defender. I will allow a waiver of formal reading. Probable cause was previously found in May. And so I will enter the not guilty plea and have noted the speedy trial commencement as the arraignment today. At this time, I will turn to the city for the recommendation on conditions of release, and then I will allow counsel to respond. City?
Thank you, Your Honor. And I was working on that previous motion, so I just want to confirm that we have Miss Alicia Armstrong.
Yes.
Okay. Your Honor, I had the opportunity to review the docket on this, and it looks like notice had been sent previously to the wrong apartment number. Given that and her history, I don't object to releasing Miss Arnold on her promise to return with standard conditions as appointed by the court.
Okay. Well, then, defense?
Defense has no objection to releasing the defendant on her own personal recognizance based on the nonviolent nature of the charge. We don't believe that she's a danger to society. And also she has no outstanding warrant, so we do not believe that she will have a problem reappearing.
And I do think I would like to add for the record, apologize. I believe when I was looking at the docket, I noticed that she'd been set for a bench warrant quash in November. And so because she was picked up prior to being heard on the bench warrant quash, that also
Right, that hearing?
yes, that struck the hearing, but that also played into or was part of my reasoning. Yes.
I get it now, because she had taken some diligence to set a bench warrant quash.
Yes.
So you felt that that was another reason she was not a flight risk.
Yes.
Okay, I will release you on your own recognizance today, ma'am, on your promise to appear at all your court dates, have law-abiding behavior, update your address if it changes, and only use your true and correct name and date of birth. You will have a court date at Lakewood Municipal Court on November 26th at 2 p.m. Do you know where the Lakewood Court is?
Yes.
And you're going to receive paperwork with that court date, your attorney's contact information, and your conditions of release. Anything further from either of the parties?
No, Your Honor.
No, Your Honor.
Any questions, ma'am, of the court?
No.
All right. Parties review the pretrial release order, otherwise, and then I'll sign, and you'll receive that paperwork today and be released at some point today, ma'am, okay?
Okay.
Good luck. We'll see you in Lakewood.
So basically just act like you're supposed to act normally, and that's your bond conditions. Man, I'm just striking out tonight.
And Your Honor, I did.
Let's see. They didn't have anything else interesting. Oh, we have a chance. We have a chance.
Stephen L. Cologne.
All right. What's your name, please?
Stephen L. Cologne.
Stephen Cologne. Okay, we're on for an arraignment and an SOC compliance. Is that your true correct name? Just a second. Stephen Lorenzo Colon?
Yes, Your Honor.
Okay, great. And September 29th of 1993 is your date of birth?
Yes, Your Honor.
Do you still reside or receive mail at the 3713 address in Spanaway?
No, I do not.
You have a new address?
Yes,
Or-
I don't know it at the moment. I'm kind of in between houses at the moment. I'm living with my sister and university, but I don't know the address by heart.
All right. Well, make sure that you give your current address to your attorney, and then they can update our records in regards to that. Did you have an opportunity to discuss with the attorney the constitutional rights that attach at arraignment?
Yes, Your Honor.
Did you have any questions of the court about those?
No, Your Honor.
Okay, I'll turn it over to counsel.
Yes, Your Honor. Sophia Arnold, Rule 9. For the record, present with Stephen Colon. The defendant has received the city's criminal complaint. Defense will waive a formal reading and ask the court to enter a plea of not guilty and also stipulate to probable cause for today's hearing only. And after screening the defendant, he does qualify for court-appointed counsel. We ask to be appointed to his case. Thanks.
Thank you. And so I will allow the waiver formal reading, enter the stipulation and the not guilty plea, and I will directly appoint the public defender based on the representations as an officer of the court. At this point, sir, I'm going to turn to the city, get the recommendation on conditions of release, and then I'll allow your counsel to respond. City?
Thank you, Your Honor. I've had the opportunity to review Mr. Colon's history. He has no warrant history. He has limited criminal history. The history that gives me pause is the history of different protection orders and domestic violence claims. Most of those don't include the victim in this case. We have spoken with the victim. I have looked at the incident report. With all of that in mind, we're not seeking any bail or bond in this case. I do not object to him being released on his own recognizance and promise to return with standard conditions. I would like to stress that so long as the no contact order is in place, it is to be abided by, that it is part of the defendant's SOC agreement. And until or if that is addressed, that might be a different scenario, but it is active and he must abide by that no contact order.
All right, defense?
Yes, Your Honor. Defense would just like to further go with what the city said. His criminal history is very limited. He has no warrant history. We understand that he needs to comply with that no contact order, and adding in the fact that, as the defendant told you, he's now living with his sister in University Place. So we believe that that will aid him in complying with this no contact order. Thank you.
Okay, I will release you today, sir, but you understand the city's made a strong caution about abiding by any no contact or protection orders. And that's the difference between you being held in custody and not, because I imagine they are not going to agree to release if there's another allegation. And even if they did agree, the court might not agree. So you have every incentive to protect yourself by not violating any of the court's orders, okay? I'll set you for pretrial December 5th at 1 p.m. You must appear for that hearing. You've been appointed to counsel, and their contact information is on your court order, as well as the court date and your conditions of release. Any questions for the court, sir?
No.
Anything further from either of the parties?
No, Your Honor.
All right. The parties want to review the pretrial release order. Otherwise, sir, I'll ask that you be given copies of that prior to your release. If for some reason you're not given copies or you lose them, you stop by the court, you get a copy of your orders, and it will have your attorney's contact and all the information you need on it, okay? All right. I wish you good luck, sir. Sign the order.
I'm so sorry, guys.
Do I sign something?
You will receive copies of it. I did forget to add Parties will have to re-sign because I am adding the speedy. Apologize, that's a new checkbox for me, so I'm gonna miss it a few times. I apologize about that, but eventually I will not forget. I hope. All right, thank you, sir.
Thank you.
Oh, looks like we got Glenn Serio's cousin coming up.
One case that there's the
I really do try.
Yes, Your Honor. This is the one case that there's the conflict attorney. It's Resnack that's on it.
That one's for me.
Okay.
Good morning.
All right. So we'll put you in a different breakout room if you need one. Okay. Here we go. We'll try it again. What's the last name of the client before you go?
They got it. It's Mr. DeLuna here.
Great.
Come on, Mr. DeLuna, you can make it interesting. Only you can do it, Mr. DeLuna.
Whenever the court is ready.
Okay. Going back on the record, give us just a moment here. All right, and how are we proceeding today? If you could just call the case with the case numbers and your client, then we'll go forward here.
Yes, Your Honor. This is case number 24L000801. Matthew DeLuna. I'm Matthew Macklin for Mr. DeLuna. As much as I'm glad to see you today, Your Honor, I'm disappointed Judge Mansfield isn't here because this is our pretrial number 6, and we're finally wrapping it up, I think. The defense and the city have come to an agreement on a plea. We're ready to enter that plea and recommendation along with a motion to modify a previous no contact order because of some circumstances previously discussed with the court, but I'm more than willing to go back over that with Your Honor if you would like.
All right, well, we certainly can do that. If the parties want to proceed today, that's great. And so let me see here. City have any record they want to make? Or you can.
I'll reserve.
Yeah. Okay, let me just upload a judgment and sentence and then I'll start looking at the guilty plea. Did you have any colloquy that you wanted to put on the record, counsel?
No.
And good morning, Mr. DeLuna.
Good morning, ma'am.
Do you have any questions before we get started as to what it means to plead guilty, or do you feel like your attorney answered all your questions?
He answered all my questions.
Okay. So I'm just going to confirm your true and correct name is Matthew James DeLuna.
Yes, ma'am.
You're 49 years old. And what was the last grade you completed in school?
12th.
12th. Okay. And did you read through the guilty plea in its entirety with your attorney?
He read it, yes.
He read it to you. And is it your understanding that you are asking the court to accept a guilty plea on one count of assault 4th degree and a guilty plea on one count of malicious mischief, and pursuant to successful entries on those two, there would be a dismissal of one count of harassment? Is that your understanding?
Yes, ma'am.
You understand that significant constitutional rights attached when you were arraigned on these matters, and you're giving up all those rights except for your right to an attorney. Do you understand that?
Yes, ma'am.
And do you understand that there is a plea agreement, but I'm not bound to that? What that means is I don't have to follow it. I can impose anything up to the maximum if I decide that's more appropriate in your unique case. Do you understand that?
Yes, ma'am.
All right. And did your attorney go over the maximum and minimum consequences with you?
Yes,
And did your attorney talk to you about collateral or immigration consequences that could result from pleading guilty?
I'm not an immigrant.
Okay. And it looks like there's no statement of facts, but it also not indicated if it's an Alford plea. So counsel, was there going to be a statement of facts put in the guilty plea?
Not at this, no, Your Honor.
Oh, okay. So how are we proceeding? We need
We're
a,
gonna proceed with the complaint. Stipulate to the facts of the complaint.
okay.
Judge looks confused.
Well, I don't have a copy of the complaint. So does the city have a copy of the complaint handy?
Let me get in here and it'll take me a minute to find it, Your Honor.
I have it if there's a handy email.
Well, no, I can access it. I need the language from it. So either you can read it into the record or the prosecutor can.
I didn't realize Ms. Pace was in the courtroom. I could tell now that I'm looking closer at the screen, so.
Mr. Macklin, if you have it in front of you, it'll take me a couple minutes to find it, but if you have
I
it.
I do. Excuse me. The city of Lakewood, by and through the undersigned attorney, accused the above captioned defendant of the following offense. Count 1, assault in the 4th degree, domestic violence. On or about November 28th, 2023, within the corporate boundaries of the city of Lakewood, the defendant did assault another person, Vander Giesen, Asia Marie, date of birth 15 May 1984, spouse, and furthermore, the defendant commit the above crime against the intimate partner, family, or household member, contrary to revised Code of Washington 10.99.020, and or in violation of the RCW 9A.36.041. The maximum penalty is 364 days in jail or a $5,000 fine, or both, pursuant to RCW 9A.36.0412 and 9A.20.0212, plus restitution, assessments, and court costs. The mandatory penalty: upon conviction, the defendant may not possess, own, or have rights or have under their control any firearm unless the right to do so is restored by a superior court in Washington State or by a federal court if required. The defendant must immediately surrender any concealed pistol license under RCW 9.41.040. Count 2 of harassment is dismissed. Count 3, malicious mischief in the 3rd degree, domestic violence, RCW 9A.48.0901A. On or about 28 November 23, within the corporate bounds of the city of Lakewood, state of Washington, the defendant did knowingly and maliciously cause $750 or less in physical damage to the property of another, to wit, Vander Giesen, Asia Marie, date of birth 5/15/84, spouse, and furthermore, the defendant did commit the above crime against a family or household member, contrary to Revised Code 10.99.020, all contrary to Section 9A.48.090 of the Revised Code of Washington. Maximum penalty is 364 days in jail or $5,000 fine, or both, pursuant to the Revised Code of Washington 9A.48.0902 and RCW 9A.20.0212, plus restitution, assessments, and court cost.
All right. And sir, are you allowing those statements to be admitted against you as part of your guilty plea and as part of the statement of facts?
Yeah,
How do you plead to one count of assault in the 4th degree, guilty or not guilty?
guilty,
And how do you plead to one count of malicious mischief in the 3rd degree, guilty or not guilty?
guilty.
Did anyone threaten you, pressure you, coerce you in any way into pleading guilty today, sir?
No, ma'am.
Are you doing so of your own free will?
Yes,
Okay, I'll accept the plea as knowingly, voluntarily, intelligently made. I'll find there's an adequate factual basis to support the plea, and I'll find you've been advised of the nature of the charges and the consequences of the plea. I do find you guilty. You have a right to make a statement prior to your sentencing, sir. You don't have to make a statement, but you have a right to do so. I'll hear from the attorneys, and then I'll allow you to make any statement you want the court to consider regarding your sentencing. Go ahead. I'll start with the city, actually.
Thank you, Your Honor. I'd like to start with formally putting the motion to dismiss on the record. because Mr. DeLuna, and based on his guilty plea to assault in the 4th degree and malicious mischief in the 3rd charges, the city does move to dismiss the harassment domestic violence charge with prejudice. As to sentencing, Your Honor, this is a recommended sentencing based on, from my account of all of the communications and my own personal communication with Mr. Macklin, a lot of negotiation, and takes into consideration Mr. DeLuna's history, his current status, as well as his desire to seek treatment. For all of those reasons, the city is asking the court to follow the recommendation that's negotiated between the parties today.
Okay, and just to confirm from the city's perspective, how much credit would he have on these matters?
I have not calculated them recently. I apologize. I can put that on the record in a few minutes if the court would give me just a couple minutes and come back to me.
Sure. And I'm just, for some reason, the numbers were switched on the judgment sentence. Okay. And I'll hear from council.
Thank you, Your Honor. Yes, in agreement with the city, this has been a long road. Mr. DeLuna and his estranged spouse have had a long road. Mr. DeLuna is more than willing to do better to recover from alcohol and drug abuse that he's had for a lot of years. His treatment is being sought is at his own initiative. He's motivated to regain custody of his children who are in foster care currently. We asked the court to follow the city and the defense's recommendation on the plea for those reasons and help Mr. DeLuna get to the next better stage of his life.
All right. And did you have a calculation of credit for time served that you wanted to submit, or are you going to rely on the prosecutor's count?
I'll rely on the city. We've got a lot of overlap and I came in late to the case. So.
Okay. And then as far as what I could read from the plea agreement, it looked like there was inpatient, and then I imagine the intention was a substance use disorder evaluation. And was that coupled with some sort of domestic violence evaluation, or just the substance use evaluation, or what did parties anticipate that would look like as far as the recommendation?
Well, because there's a few different causes with this whole situation, I went ahead and included that treatment so that there would be no confusion with transport. Mr. DeLuna has already been evaluated, already been accepted. The bed date is set up. We just want to make sure there were no hiccups there. That's why it's a standalone without any other conditions related to DV.
That's my understanding as well. I believe that there is some other treatment that and some other, based on his previous case, I think that there might have been some other words escape me. I'm so sorry, Your Honor.
Conditions.
Conditions is the word I was looking for.
I believe so as well, but I wasn't on that case. One more thing to add, Your Honor, there is another no contact order in the system from previous cases and things. The modification there is to remove the children from the initial no contact from last year. That was from recommendation from the department, and the case manager is working on that custody case so that visitation can begin and we can start the dependency, reuniting that family as well. That's why that no contact order modification is there. It still includes Miss Vander Giesen.
Okay, I'm just still trying to understand the treatment part of it, because I see it's delineated that he's going to inpatient treatment. What I'm trying to determine from the parties is, was it intended that then he would do whatever's required after the inpatient? Because usually inpatient can be 30, 60, 90, sometimes
Yes.
120 days.
Yes.
And then it would be a typical.
As a true furlough, yes.
Right.
It to be a true furlough, pausing the time for commitment, yes.
Okay, okay. So the time that came through was only 30 days on one, and
the treatment center is currently docking 30 days. That could be extended according to need, of course, after he arrives, but it is initially for a 30-day time. Mr. DeLuna is also serving on the other case until May. So it's not going to, and this is a concurrent sentence, so it's not going to really interfere, even if it is extended. That's why it's not really.
I see. So he's already serving a substantial amount of time on, okay, and I didn't know any of that. So that's where I was confused, like how, I don't understand where we're
We
going.
take for granted that
I
we've
gotcha.
been doing this 6 times now. So
I
yeah.
understand. I understand. I'm coming very late in the game here. So I'm just trying to make sure I understand it so that my judgment sentence doesn't conflict, but supports what the parties are intending here. Okay. Thank you for clarifying that. And then, sir, did you have any comments you wanted the court to consider in regards to your sentence?
I really need to go to drug and alcohol treatment. I've been a drug and alcoholic for 30 plus years. I've never known any other way of life. That's why I'm in jail, is because due to drugs and alcohol. I don't get to see my kids due to drugs and alcohol. And I need that change. I'm 49 years old. I have grown children and little children that both miss me dearly, and I need to get my life back together and be the father, as my older daughter Mary said, is the father that this is the father she likes now, the one that's not on drugs, not on alcohol. And that's the father I need to be, and I need this treatment to do so.
Okay.
Your
All right.
Honor, when you're ready, I believe I've calculated the time. It appears that time started on when bail was set while he was in custody, May 31st of 2024. By my calculation, that is 155 days.
And so the recommendation was substantially less than that. So is that all credit against these 2 charges? You see where I'm going with this? Because the recommendation was 348 on one with, so that's a little over 30 days, and the other one was 334. So if they're all concurrent, if he, I don't know how the parties were anticipating the calculation, because I know he's serving on another matter. And so I just want to make sure that the judgment and sentence reflects what the anticipated parties, because, I'm going to give my cards away now. I'm going to follow the recommendation, as there was already substantial jail time imposed. And I understand that the agreement is for a furlough for him to go into inpatient. I just don't know how to set this judgment sentence, other than if you do the furlough on the other cases. I've already accepted a guilty plea. You could reserve sentencing on this one, and then he returns and being sentenced on that. I don't know. I'm trying to make it the least confusing. You see what I'm saying? I'm trying to make it the least confusing possible.
I think to serve the clerical due would be fine with the defense to implement the sentence today.
Okay.
To run concurrent with the current sentence. And then that would allow the order to be active for the purposes of treatment, and then simply expire. We'd waive any time served at this point. He's going to be serving on the other sentence until May anyhow, which will cover the 45 days.
Right. That leaves very little penalty remaining at the end. And so that's, just to be blunt, that leaves very little incentive for him to complete it when almost all the jail time will then be served.
We could, if the city agrees, it is probably safest just to reserve, as you say, and then proceed with the furlough and come back to. Is that what you're suggesting?
I really don't have an opinion either way. I'm just putting both thoughts out there, because I didn't realize there was another sentence already being served. And so from the court's perspective, when we're talking about, I think you said 155 days already served, that leaves plus another 30, 180, you're talking half the sentence has already been served on each of these matters. And so I'm just making sure that everyone understands what's going to happen if that's the order of the court. Yeah.
So, well, make sure I'm understanding. So my understanding is that we agreed to suspending all but 45 days, right? On both counts total. Did I have that background?
But he's already served
If he's already served 150 days and you've agreed to 30 or 40, do you see how that goes into negative numbers now? So that doesn't make any sense to the way I can calculate. So that's where I'm trying to figure out what it was anticipated by the parties. If you're saying he's already served it, he doesn't need a furlough on these matters because he's already served more than you guys have agreed to.
My concern is that if this to be the operative order so that he truly gets the furlough on the other sentence, or do we need to go back to that case, which I'm not counsel for, to ensure that there's a furlough there if we're doing time served on this case?
Your Honor, I think that reserving sentencing until after he's done with the furlough does make the most sense.
This is a credit for time served and he's already served it. So.
But the idea was to furlough him under this sentence. I see what the issue is. So I think
I understand perfectly, and that's, I want it to happen appropriately. So you see what I mean? You don't need a furlough on the ones we're handling today because he's already served the time, right? So really, and the other case isn't calendared. Those cases aren't calendared today. So we're not solving what you're actually trying to do. This is where I'm concerned about spending all this time on this, and he doesn't get furloughed for inpatient. We're not even addressing the review matters. They're not even calendared for today. So that
sounds like you need a 7th pretrial.
Just a little bit more history too. They were originally under the same calls number and they were out of order. So that's why it's under a new calls number even. So they're related cases. And I think if we reserve judgment on this one, this will be the operative case for the purposes of overriding the NCO and for the purposes of furlough. We can return back at a future date, closer to May even, and simply enter the plea as time served at that point. So that way we're not interfering with whatever, and both Ms. Pace and myself were not involved in those previous cases. So it's kind of a lot of unknowns there. By making this the operative case for all of them, we're in the safest spot, I think.
Okay, well, you've talked a lot about this case being furloughed, and I'm just telling you that there's no furlough hooked to this case. Are you understanding that?
I do, and that's what we're asking for, which is also why we're asking to reserve the judgment. Otherwise, this case is done.
Right, I thought you just said you wanted to have the judgment today, and then you just said reserve the judgment. So now I'm very confused.
If we can, and I guess I'm thinking, it's all working in my head. So we would need a separate order for the furlough. You're right. It wouldn't be in the guilty plea.
Yes.
Or in the judgment, at least.
Right. Yeah. So are we doing a sentencing today on these newer charges that have nothing to do with the inpatient furlough, even though that was in the recommendation of the plea agreement, but you also recommended credit for time served. So you don't need a furlough when you've already found credit for time served. So what you could do is note those other matters for immediate, we can hear them, as early as probably Friday, as far as the review matters or whatever the agreement of the parties. I don't, okay. Right? And then we just release him on these matters for sentencing purposes. He comes back for the sentencing on these matters that aren't prohibiting him from going to inpatient. And then it keeps the two sets of matters separate, and then it isn't muddy with the furlough. I don't know. I'm not trying, all I'm trying to do is make it clean, and it feels like it's getting messier. So I'm not intending to mess anything up here. It's just what I'm understanding is a credit for time served recommendation on these, and that has nothing to do with the furlough if there's a credit for time served.
It is messy.
I'll defer to the city. I think that's the cleanest. I think it was messy to start with, is how we got here. Okay. So if we do that today, I'll appear on the other matter. We can renote it for Friday if Ms. Pace is available, and we can simply enter the furlough there. And that way we can close this case out and be finished.
All right.
Is that am I understanding?
That works. Mr. Vinson will be here Friday, but I will let him know what's going on.
Okay.
Now, one more thing on the no contact order. Are we able to go ahead and do that today since they're all Lakewood no contacts?
I don't see why not.
We could adjust because now it's a condition of sentence. It would no longer be a pretrial no contact order. We can enforce, because that will be a condition of sentence. We can enforce a sentencing no contact order. I'm happy to do that today. And otherwise we'll reset sentencing, the formal sentencing, till after the inpatient, the furlough, and then what the next steps are. And then that will probably be more meaningful. I understand, and the parties still have their recommendation of the, whatever the credit is. So I'm going to trash the judgment and sentence document, and we're going to address the no contact order. And then you are noting and requesting that his review matters under 23L001484 be set for Friday. Does that sound right?
That is my understanding, yes.
That sound satisfactory to the city?
Satisfactory to the city.
Okay.
And Ms. Pace, if we could do that in the afternoon or have Mr. Vincent note it for the afternoon, I am in a hearing in the morning until.
I believe Nisqually is set at 11 on Fridays.
I can do it. I'll just be late.
Okay, well, they might have to take you last or
Yeah.
later. So what I'm going to do is I'm going to do the firearm sentencing because now he has been convicted. And so I'm going to sign the firearms order because in an abundance of caution, since we're going to do a release on this matter, we'll do a notice of hearing for sentencing. We're going to trash the judgment sentence, and I am going to impose a sentencing post-conviction no contact order that has the adjustments that have been made under the paragraph. So have you reviewed that, counsel?
Yes.
Okay, so if that's acceptable to the parties, I'll sign that as uploaded and provided. And I'll sign that. And so you'll get copies of both of those, sir. So today you'll get a copy of firearms order, the new no contact order that was issued today. We will recall the other no contact order. Do I need a separate order to the recall for the? Okay, that'll revoke the other one. And we'll have a notice of hearing, which will indicate that you're going to come back for sentencing down the road. And you will also have the other matters noted for Friday. Is it? Okay. Okay, all right. All right, so the order on motion, let's see. We could put that the 801 matters, set for sentencing. Okay, so let's look at a sentencing date that presumably would be out of custody. And how far out do you think would be prudent between the city and the defense?
Well, he is likely to be in custody, and he'll, after his
Yeah,
inpatient treatment, he'll go back. He's likely to be in custody until May sometime, I believe.
So tentatively, let's just set a May date, early May. And May 3rd. Okay. So let me put it to, I'm going to set it on a review. Let's see. Could I put the sentencing on a review calendar on April 17th? On April 17th, that way that'll trigger the parties to know it's coming. And I don't want to lose track of it, and that he'll be sentenced. And I will put, oh, that makes sense. We're going to change that to an in custody date that to make it easy because he returns to in custody and then we'll have him. Yeah, okay. We're going to look at that for a minute and I'm going to fashion the order. This is going to be that over sentencing for completion of inpatient furlough on review matters. I'm just saying what I'm going to type, and then if you guys disagree, then you just tell me, no, I don't want that in there, yada, yada, okay? Patient furlough on review matters. Parties to address sentencing. post inpatient.
Well, I worked really hard to get it.
There we go. So that'll be April 16th will be the in custody hearing for sentencing, and that'll be post inpatient, you see, and then we'll be on the precipice of release for the other matter. And so that should give us that way, these charges don't mess up anything that's going on with those charges. And then he can look forward to saying, okay, now I'm proactively, this is what I'm doing. So if the parties have any problem with what the court indicated in regards to that, but otherwise I'm setting it to that day. Do we want me to put rescission of the no contact order on this? But since I think that might confuse things since we're issuing anyway. Okay, but I will also articulate release on this order since he's being released for sentencing. So on the matters that are being reset for sentencing, sir, you'll be released, okay?
Okay, what about the no contact order?
I couldn't hear, counsel, if you heard, is that a question for me or for you?
That's for you, but he wants to know the status of the no contact order.
Oh, and then I've signed and granted the new no contact order as discussed and part of the plea agreement with the parties, okay?
So I'll be able to have visits with my kids, just talk to them?
Yes.
Thank you. Thank you very much.
Wow.
I'm just adding that the review matters are going to set for Friday to review of the furlough agreement in custody matters. And that's what I've added on the order on motion. If the parties want to review that. Or if there's anything else that wants to be added to that. Otherwise, he's released on these matters. And those matters are set for Friday. And right. So interesting. DNA sample is one of the mandatory requirements. Would you like them to have Nisqually collect that, and then that way that's done, and that's not a condition that he has to do later?
Yeah, that's the best way, I think. Go ahead and have Nisqually do it.
Yeah, I want it to be as easy as possible. Okay, defendant agrees to submit to DNA sample to be collected by jail prior to release. Okay, I've added that to the order. And I'll sign that order. Hopefully this, I know it feels messier right now, but I'm hoping this is slowly gonna make everything very clean. And then that way, sir, when you get done with inpatient and you finish that sentence, then you just have a very clear path forward. Anything further from either of the parties on these matters?
I think I'm going to take the rest of the day off after that.
Right. Right, me too. Nope. I'm going back to court.
On another matter, it looks like Nisqually accidentally direct messaged me that Mr. Patrick Thomas and Williams Anthony have refused to appear, I guess. Are they on the calendar?
Thank you. That was our next question. So let's see. Anything further on Mr. DeLuna?
No, thank you, ma'am. Thank you, ma'am, for approving the.
You're welcome. You're welcome, sir. I wish you good luck. I think you're gonna just absolutely be shocked how much better your life can be in sobriety. It's gonna take hard work, but you're gonna get there. So just work hard at it. Fight for yourself.
I will, and I am. Thank you, ma'am.
All right, make sure I've signed all the orders, which I believe I have. And then we'll see you Friday. Well, it won't be me, but you'll see another judge on Friday.
Thank you. Thank you, Ms. Basin.
Take care.
Thank you, ma'am.
All right. And
all right. Sorry. I just wanted to make sure I wasn't cutting any part of the case off, but I wanted to address that. Yes, his child or children are currently in foster care. He suffers from alcoholism, and something happened. I don't exactly know what, but it did involve DV because there was a DV charge that was dropped in part of the plea agreement. So, yeah, his children are in foster care, and he's just trying to get them back now. And he can't get them back until he goes through treatment. And they were having problems setting up treatment because he's in other charges currently, and it was a big mess that, like, I would have to go back through and rewatch it and take notes to keep up with what they were going through there. I don't know if they would have had the same level of confusion or difficulty if the original judge that was on the case through the first 6 pretrials or first 5. I don't know if they would have had as much confusion, but they would have run into the same difficulty with the time served furlough thing. So that just plain old didn't get caught until this judge looked at it and said, whoa, we can't do this way because XYZ. It's required on all felony cases, and just certain charges automatically require putting your DNA on file. That's all. It wasn't that his children were involved in any type of accusation of what that would usually involve. It just was the charge mandates that he has to provide it. Yeah, good question though. Absolutely good question. All right, guys. I held on until I found one good one, but I need to go to sleep. There's a really good chance I'm going to have to go stay with Dad starting tomorrow again. So maybe I'll pass out candy from his house, which is probably good because I didn't get any candy for this house. But I'll definitely take mine in Ava's costume. And you might be seeing me stream from my childhood home again. Terrible lighting and all. Everywhere I go is terrible lighting. It's terrible lighting here, but I've got it set up with, I've got the main light, and then I've got an extra lantern, and then Palmy got me a desk that has a light under the platform that the computers are on. So between Palmy and I, we got this rigged. I will just keep praying. Absolutely will. Thank you, guys. All right. It's been fun. The edited stuff was awesome, right? The court crawling was, what the heck? The best we got out of the first half hour, 45 minutes of that was a Chia Pet hairstyle. It was probably longer than that. I'm a terrible judge of time when I'm this tired. I love you. I love you all. Be safe, be well, sleep sweet, and much love.